Not only are we late, but we're holding up the room from lunch, and I can see a few yawns and a few mobile phones out. So I think let's try and engage in this final session for lunch, and then we'll have a nice lunch. Welcome to my panel. I'll do very quick introductions and then we'll crack on, and I'm going to switch on my stopwatch to make sure we finish ahead of time. It's going to be like a Zoom call, right? When you finish your Zoom call early, everyone breathes a sigh of relief that you've got some time back. To my immediate left, pleased to welcome Saad Al-Mansour. Saad is founder and managing director and partner of Alsharani and Almansour and DLA Piper law firm. To his left is Alex Leventhal. Alex is a partner at Quinn Emanuel and is over from Paris. To Alex's left is Sara Aranjo. Sara is a partner at Tamimi law firm in Dubai. And to Sara's left is James Abbott. James is a partner at Clifford here in Dubai. And right at the end is Stuart Paterson. Stuart is a partner at Herbert Freehills. So I think I will start. If I introduced you last, Stuart, so I might start with you right at the end, furthest away from me. We've heard a lot. We've heard a lot about where the SCCA has progressed in the last 12 months, and we've heard a lot about GCC arbitration in particular. In your view, is there genuine domestic support for international arbitration in the GCC? Does it really exist, or are we playing a bit of lip service?
Is this working? Great. Thank you. I think it would be dangerous to say no to that question, given the content.
We'll see if the audience is awake.
And it'd be great to hear what people in the audience also think about it. But if I can offer a few thoughts, it seems to me that you can look at this from the perspective of three factors. First of all, a country's legislation that supports arbitration, the arbitration framework. Secondly, in terms of the courts and whether the courts are supporting arbitration. And thirdly, the institutions that conduct and promote arbitration. And of course, there's a big overlap between all of those three. In terms of the legislation, clearly it's a positive story. Many of the GCC states, in fact, the majority of them have modern arbitration laws and have done a lot to improve those laws over the last few years. Certainly Saudi Arabia and the UAE being good examples of that. And you can look also to the free zones that have developed an infrastructure that is very much supportive of arbitration in the UAE in particular, but not just the UAE, also Qatar and Bahrain has a similar construct. So I think it would be fair to say that at a very high level, the legislative infrastructure in the GCC is a very, very positive environment for supporting arbitration. There are areas that are, I think, a little bit less easy to say are consistent with that proposition. I think there are some things like the requirements in some countries for specific government consent, typically from the Ministry of Finance, for a government entity or a state entity to enter into an arbitration agreement, which are perhaps slightly outliers in terms of whether there is real support for arbitration, possibly a lack of trust in the system. But those are, I think, really small points in the overall scheme of things. In relation to the court system, I would say that most courts of the region are on a positive trajectory in terms of supporting arbitration. We often hear cases that could be described, I think, as horror stories in terms of how a court has perhaps failed to understand an arbitration agreement or an award that's resulted from it, and therefore failed to deal with an enforcement application or similar in respect of it. But I think those cases really are the outliers. There are a few of them, and you get those in any part of the world. So I don't think this area of the world is anything special in that respect. Is better training, better awareness. So for me, one area to sort of take away is that it's investment not just in the dare I say the sort of sales and marketing side of arbitration, but the actual delivery. And I'd like to see real improvement in that area as my one key request to institutions in the region.
Thanks, Stuart. You made one interesting point. You made reference to the requirement on occasions for Ministry of Finance consent, which historically we've become accustomed to in Saudi Arabia. I might just ask Saad a quick question in relation to this obligation, and to what extent does this remain an issue or a concern in the kingdom?
Thank you very much, Haroon. The general view is that if the agreement containing the arbitration clause is with a government entity, certain approval remains required, whether from the Minister of Finance or whether from the Prime Minister. Perhaps an important issue relating to that is, assuming that there is no approval required and the agreement went ahead and the arbitration clause is there and a dispute arises, what would be the case for that arbitration clause? I mean, would it survive or it would be considered invalid? I think it remains an issue, though what I have seen is that from both the arbitral tribunal and, more importantly, how the courts treated it, it remains an issue, obviously, but it is an procedural error from the government entity not to obtain such approval, and it is likely that while it is obviously endangers the arbitration, it could be argued that it would not affect the survival, if you will, of the arbitration clause. However, it remains a requirement, and it is very important to make sure that if it is a government entity, that the appropriate approvals are obtained.
Thank you for reflecting on that point, Saad. I'll move over to Alex. Alex, Stuart has set the scene for us in relation to GCC arbitration. And if we now pivot over to Saudi arbitration in particular, and yourself being a disputes lawyer based in Paris, obviously with experience of the Saudi arbitration law, from your perspective, where is arbitration going in Saudi Arabia at the moment?
Sure. So a decade has now passed since the 2012 law went into force, and I think that law led to a flurry of legislative activity that created 4 pillars of an arbitration regime in Saudi Arabia. And it's one that I've kept a keen interest in, as I wrote a commentary 10 years ago on the 2012 law. I did not then, and I do not now contend to comment on that law from a Saudi law perspective. I leave that to the gentleman to my right, who is much more qualified to do so. But instead, as an arbitration practitioner with experience in my home jurisdictions, as well as with experience in the kingdom as well. That law eliminated a number of mandatory requirements and vested power in the parties in the tribunal to do a number of things. Agree on an institution, choose arbitrators of their liking, separate their arbitration agreement from the underlying contract, etc. But of course, an arbitration regime requires a judiciary that enforces that. And that brings me to what I would say is the second pillar, which is the enforcement regime. And I think that the greatest advantage of this enforcement regime has been the specialization in judiciary, in particular judges and a particular court to hear challenges as well as enforcement actions. And I was heartened to see the very interesting statistics this morning that Chris presented to us. When one compares the earlier decisions of the Diwan al-Mazalim with the more recent decisions now, one sees that the courts of the Kingdom of Saudi Arabia will get out of the way when parties have agreed to arbitration, but will also facilitate arbitration when there are issues at the start, for example, in constituting the tribunal. They'll refuse enforcement or set aside an award only on limited grounds that are internationally recognized. And of course, they will enforce awards against Saudi parties as well. Now, the third pillar, I think, is the creation of the SCCA, which has been an instrumental actor and voice for arbitration in the kingdom, not only within, but without. And the key role it has played, we've heard about this morning, is sensitizing the judiciary to arbitration and the demands of international arbitration. And finally, the fourth pillar would be the recent legislative initiatives that have both authorized government entities to enter into arbitration agreements and have encouraged arbitration in various sectors. That is incredibly important, not only because the public sector has a large role in the Saudi economy, but also because the private sector will have an increasingly large role in the economy as Saudi Vision 2030 rolls out. So where are we going from here? Obviously, creating an arbitration hub doesn't happen overnight. It takes time for parties to put arbitration agreements in their contracts and also for disputes to arise out of those contracts. But I think an interesting parallel can be drawn with Singapore. Obviously a very different context, but there's an interesting impetus. I liked the new phrase that I heard today, glocal. I think that Saudi Arabia is well placed to be both a local hub because it is the largest economy in the region, which of course Singapore was not. But also a global hub because it is a key place in the world economy. I think the next challenges and opportunities that Saudi Arabia will face will be to consolidate this arbitration regime and to let others know that Saudi Arabia is a place that is open for an arbitration-friendly hub that parties can choose as a seat of arbitration.
Thanks, Alex. You've touched upon the reforms in the last 10 years, of which, of course, there have been many. I might go to you now, Saad. Yes, we've seen reform. Yes, we've seen improvement. But if we look at some of the challenges and particularly the duration of an arbitration or in instances where a party has procedural challenges, an urgent request, what are the challenges being faced in the kingdom at the moment, particularly if it's an ad hoc arbitration seated in Saudi?
Thank you very much. The challenges remain. The good thing, I believe, is most of those challenges, if the parties opt to an institutional arbitration clause like the SCCA, most of those challenges do not become challenges anymore. Take, for example, the issue with the duration. The current arbitration law, the current Saudi arbitration law provides that the duration of the arbitration is 12 months, starting from the commencement of the arbitration. Now, when we come and look at the definition of the commencement of arbitration, we find out that it means the moment that the respondent receives the notice of arbitration. Now, the time between receiving that notice and having the tribunal constituted can take sometimes the whole 12 months period. That is one issue. What I have seen, and what also Chris thankfully showed us this morning, and what has been my experience, is that the court generally takes the view that if the duration exceeded the underlying time of the arbitration law, of no fault or of no material negligence from the tribunal, the request to terminate from one of the parties to the arbitration, it would typically be denied, so that the parties do not use the duration as an excuse to waive the arbitration entirely. As I mentioned, and as we've heard this morning from the SCCA rules do not mention duration. It is left, it is up to the tribunal, and there would still be some discussions and dialogue whether this part of the arbitration law would remain applicable to the SCCA rules or not. And one of the points perhaps worth mentioning is the role of the SCCA in creating dialogues with the relevant judicial authorities to reach into an agreement or to reach into an understanding of how those articles are interpreted and applied. Ultimately, I think the ultimate role is to close those gaps by either amending or having further amendments to the current law. Another issue, Haroon, is the urgent requests, precautionary measures, if it is an ad hoc arbitration. Again, it would not be applicable to that extent if it is an institutional arbitration. One of the articles of the Saudi Arabian arbitration law is that before the arbitration commences, the relevant authority to consider urgent requests is the relevant court, which is the appeal court in the kingdom. That is, before the arbitration commences, that is, before the respondent receives the notice of arbitration. Back to the point I mentioned, receiving the notice of arbitration and until the tribunal is constituted, it can take up a substantial amount of time, and with urgent requests with the precautionary measures that the party want, this specific period between the constitution of arbitration and the commencement of arbitration, to some extent, there appears to be a gap in the law where the parties go, at least theoretically. Practically speaking, a quick look at the relevant judgments from the appeal court, even though the arbitration law says if the arbitration commences, then the relevant court has no jurisdiction, to some extent, the interpretation of that, they link it to the constitution of the arbitral tribunal, which frankly makes sense. If the arbitral tribunal is constituted, then apply the urgent request or the precautionary measure. Before that, even though the arbitration commenced, practically speaking, the appeal court or the relevant court in Saudi still accepts some urgent request. It would obviously be left to the discretionary of the relevant judges, but it is practically, or it is at least in terms of law, there's a gap which I think it requires a certain attention.
That's interesting. Would you say? I mean, you spoke about the SCCA. To what extent then, if there's an arbitration, let's consider kingdom arbitration under the auspices of the chambers of commerce, for example, will that raise a number of difficult practical issues that a party would have to navigate? Would you say?
I think that would likely be the case. Obviously, each arbitration is different, but you would still see a lot of ad hoc arbitration, I think, currently from contracts that were signed years and years ago before the establishment of the SCCA. And I think they will have them even years to come. A lot of the issues, again, do not become issues from what I have seen if the parties opt to an institutional arbitration. In the case of the kingdom, take an example of appointing an arbitrator. If it is an ad hoc arbitration, you go to the appeal court to appoint an arbitrator. It can take quite some time, whereas in the case of the SCCA or institutional rules in the region, this matter is well established, if you will, and can be done rather swiftly.
Thank you. I'm a bit concerned because you're talking about issues, complications, and issues, complications mean time, and time means money, and we've got a number of lawyers on the panel, which is, we can talk about time and money with lawyers later, perhaps. But on that note, I might ask Sara a question. Sara, with some of these issues and complications and increasing time and costs, and bearing in mind the current economic climate that we're presented with and faced with, to what extent do you see this as a challenge to the growth of the use of arbitration generally in the region at the moment?
Thank you, Haroon, and good morning to everyone. And first of all, allow me to thank the SCCA for the very kind invitation to be with you all here. And I'm extremely delighted to see the wonderful turnout. And congratulations to Dr. Hamid and the leadership at SCCA for those extraneous efforts which have led to the recent setup in Dubai. And I'm very proud and delighted to see these recent developments. Putting things maybe into perspective, you've touched upon two critical factors, which are obviously time and costs. And those factors obviously work in tandem. And because today's topic, obviously the title of the symposium is to make a case for ADR, and that is obviously a very rightful title, because we're not necessarily only talking about arbitration, but we're talking obviously about alternative means of resolving disputes. And so when we look at those alternative means of disputes and the rationale behind them, so if we sort of backtracked for many decades ago, we can see the interplay between the development, or I would call it even a positive correlation between the development of those alternative means to resolve disputes. And I'm talking about those that are obviously alternative, and in this part of the world, we call it alternative to the default, for the most part, constitutional right for a party to litigate before the national state courts. Hence to the point that Saad was making on that requisite sometimes authority or capacity to agree to arbitrate or to consent validly to arbitrate, is that by and large there has always been a positive correlation between the development of ADR and as well the development and the complexity and sophistication of economies. So even if when we take a global view at it, we often see that the development of alternative dispute resolution comes with the maturity of the economy. And so as more sophistication the economy tends to take, then there is also a form and the layer of complexity as well in the offering of alternative dispute resolution. Obviously the kingdom is not exception to that, and we can see that the development of ADR, not only arbitration, is high on the agenda of the KSA vision for 2030. And so when we look at this, and I would also like maybe to tie things globally to the current geopolitical developments and events happening globally, we can definitely see that there has been a push not only on time, because of the obviously factors such as unexpected, or probably some would argue expected wars, but definitely as well unexpected pandemic. And so there is definitely on one hand a push towards more expedited resolution of disputes, but also on the other hand a push and pressure on costs, which means that what I think will happen, and tying it up to the topic of this panel discussion, is there are definitely challenges and push on arbitration particularly. And maybe taking it from a flip side perspective, I also see a lot of silver linings in that, and particularly that those challenges are transformative. So on one hand, one can view it as being disruptive, but they are definitely transformative. And one definitely transformative aspect of it is that we have seen what we call today modern arbitration practices, the introduction of several means pertaining to, for example, the expedited procedures. But also I would say, and I invite some of you also to have and be on the lookout for what's forthcoming in the next few weeks, is the release of the ICC Commission Task Force report on arbitration and ADR, which is gonna push more the introduction of ADR being non-arbitration on that front, and how they can be embedded, such as, for example, mediation tools, but not necessarily as part of a med-arb or arb-med mechanism, but really in terms of the introduction of windows in the context of proceedings in support of a time and cost-efficient resolution.
I think you make some valid points, Sara, but I'm going to challenge you. To what extent, though, as practitioners, are we really making an effort to save costs? To what extent, when you're involved in a matter, or I might ask James or Stuart, chime in, please. To what extent is cost really at the forefront of the agenda, and really when we're looking at matters, advising clients, do we really have one eye on costs at the outset? Because costs can really spiral out of control pretty quickly, and it's a reluctance from parties perhaps to proceed with arbitration. So please feel free to jump in as well at the end.
Yeah, I mean, just to be very brief, I'll just maybe answer it in simple words, which is to say, costs, obviously, the bulk of them tend to be legal costs in the context of arbitration proceedings. And when you talk about legal costs, you bring it down to the nature of legal costs, which is the provision of services. So we are in an industry whereby we're producing a service. And when you're producing or aiming at least to sell a service, well, you're aiming to provide a quality service. And the quality, by definition, means that you are providing a good service, but also you're providing it at a good cost. Because if you're actually providing a good service, but at a very high cost, or also inversely, if you're providing a bad service, but also at a low cost, that service is actually not good. So definitely I can tell you from my own personal experience is that as much probably as people have probably a misconception, I would like to call it, that lawyers come in as expensive and that all they care about probably are, charging and enforcing maybe that timely hour model. I can tell you that we're in the service at the bottom line and providing a service which should balance the quality of the service that you're giving with the cost of it. But I'm also happy to hear from James and Stuart.
I think you make a very, very valuable point there, Sara, about the valuable service. Let's see what James has got to add.
Yeah, thanks, Sara and Haroon. I mean, I don't think I've ever had a client that isn't concerned about costs in the first conversation, and if they are, I'd probably have to report them to the regulator, because I'd be a bit suspicious as to why they didn't care about costs. I mean, one of the obvious ways around that is funding, and I was going to talk about funding if you want me to.
Absolutely, that's
and how that might
nice move to pivot onto that, James.
See what I did there. That might help resolve some of the issues or perceived issues with arbitration in the region in terms of cost and also difficulties in enforcement. I mean, funders are here to stay. There's been a few open their offices this week in the DRC, as you will have seen. It's probably fair to say there was a bit of a rocky start with funding in the UAE. There's a well-known case in the DRC courts where the funder had to get an injunction to make sure he got paid. So that wasn't a great start. But obviously things have moved on since then, and I think the levels of education in relation to, I don't work for a funder, by the way, it might sound like I do, but the levels of education in relation to funders have improved, and obviously they do serve a number of purposes. There are not least access to justice, a number of meritorious claims that would otherwise not be brought can be brought. Also on the enforcement side, not just the UAE, a number of jurisdictions in the region, including the Kingdom, have taken quite significant steps towards improving the enforcement regime, and that's why you see more and more funders talking about enforcement now, whereas before some of them might have seemed a bit allergic to funding enforcement cases in the region. And also resolving conflicts. And we've seen that a number of the arbitration institutions now have provisions in their rules for disclosure of the fact of funding and the identity of funders. So the ICC and DIAC rules have that, and perhaps I can make a suggestion if the SCCA is looking at revising its rules, whether they might want to think about that type of provision. I'm aware, of course, and Saad will know more about this than I will, that there may be issues with Sharia law compliance, for instance, in relation to third-party funding. There'll need to be regulation and licensing of funders, and also recovery of costs, particularly in arbitration proceedings against third-party funders. I mean, it has been done in certain other jurisdictions. And it seems to me that the SCCA's current rules in relation to costs look relatively broad, so it might be, worth a try. But again, that might be something that the SCCA might want to look at if they're revising their rules. I don't know if you want to.
I was just going to ask, sorry, Stuart, just quickly before. No, you first, Stuart. Go on. I've got a follow-up question to James, but I'll listen to your comment. No. Okay. I was going to ask you, James, to what extent would you say there'd be more of an appetite from a funder's perspective to fund if the underlying contract had an arbitration provision from an institution such as SCCA? What's the bearing of that, would you say?
Well, I'm sure I can't speak for the funders, but I've obviously done a number of matters with them, and I'm familiar with their due diligence process. I'm sure that they do look at the identity of the institution, and they probably rank them, frankly, but they're not going to discuss it in a forum like this. But they will no doubt look at the constitution of the board, the number of cases, the enforcement statistics, depending on where the arbitration is held and also where the enforcement is due to take place. But I mean, I've seen some impressive statistics coming out of the Kingdom, and I would encourage keep publishing them, because I've still got a lot of clients who think you can't enforce in the Kingdom. So it's it's sort of incumbent on all of us to try and dispel that myth. I mean, it's not perfect, but where is, frankly. So.
Sure, and I might just ask Sara. James mentioned the point of Sharia law on funding. Is that something you're coming across as a major issue at the moment from a funder's perspective? I'm swaying a bit on funding, but I think James has touched on an interesting point.
Yeah, just very briefly, and again, this is one of the probably myth of probably blaming it all on Sharia. In a way, and so this is why those statistics are always very helpful in terms of debunking, unwarranted myths in a way. And I personally look very much forward to these because that goes. I really echo what James just mentioned. It's extremely important to try and get the word out there. But in terms of funding, I mean, I would have to maybe give you a lawyer's answer, which is that it depends. And so when you look at sort of the principles of Sharia, and obviously, Sharia adopts a very permissive approach, which is what is not expressly prohibited is actually permitted. And then when you look from a financial perspective, transactions, and we obviously have an expert also in this room, Professor George Faki, with us. But some of these principles, obviously, one of them is obviously the express prohibition of, speculative gharar, for example, transactions. And so I would have to, and obviously the permission on riba. So I would say it depends. So not all third-party funded disputes are sort of prohibited. You're going to have to really look at the underlying financial terms. And obviously this is beyond the scope, and I'm leave it at that for the interested.
I think you've left it on a nice hook for us to go to the audience to see if there's any questions for our panelists. Abdullah is waving at me frantically to say lunch is getting cold. But do we have any questions for any members of our audience? Yes, please. Is there a mic we can get over there very quickly? It's great. I've got another question here. I'm pleased we've got questions.
Hello? Yes. My own understanding of the role of institutions like SCCA and others is that they are just administrative, they provide administrative assistance, or just a matter of procedural issues to be handled. But initiating something like a court, also using the term court in their rules, mimicking something else like the ACCA, ICC or something like that, this brings you to a question. Is there this is the first step of infringement on judicial system? Like the court's role and within these rules to scrutinize some issues, to look at some issues. So there are some layers. Is this like beyond the ambit, the original ambit of institutions just to provide services for arbitration? Because it's taking more and more decisive role in this matter.
I think there's a simple answer to that, and I'm going to ask Saad to answer it.
Thank you very much. I think regardless of the terminology, whether you name it a court, having institutional arbitrations centers, one of the main purposes, if you will, is to release the judicial authorities from those procedural issues when it comes to arbitration. To have, say, for example, the ICC court, which was announced recently, it's not something entirely new in the arbitration world. You have, for example, the ICC, they have their own court. I don't want to dwell when it comes to the terminology, what you name it, and the overlap between the judicial authorities and the arbitration center. But according to the arbitration law, the Saudi arbitration law, if the parties opt to institutional arbitration, whatever that institutional arbitration rules say would be applicable. The court would not deal with the substance of the case. That is left to obviously the tribunal, but it deals with various procedural matters, which frankly is one of the significant points of institutional arbitration.
I would just maybe add to that, by way of clarification, as a member of the ICC court, but also the Saudi court, is that you're absolutely right. The court doesn't necessarily have the bearing in terms of terminology of a state court and the mandate of an arbitration court, because those are quite common, and it's not really a position where the Saudi center is replicating or other centers. The terminology of an arbitration court is quite prevailing and quite now globally established at different levels of different arbitration institutions. But maybe my 2 cents on it is that the word of court, maybe if it's of help to the audience, of an arbitration court, is definitely not to decide disputes, because the mandate of deciding disputes in the context of arbitration falls exclusively with the arbitral tribunal. And so Saad has very rightfully mentioned that the court more generally, and it varies from a center to the other. For example, at the ICC level, the court primarily scrutinizes award, and obviously the role and duties of court members would vary. But the terminology of court dates back to around 100 years ago. And it goes back to the point that Jean-Rémy Demestre, and I don't know if Jean-Rémy is in the room, about the merchants of peace at the time. And this is a little bit the foundational and philosophical aspect at the time, about 100 years ago, when arbitration and the ICC, for example, started rolling it out. The purpose really of arbitration was to resolve disputes. And it was an honorific, prestigious title to call on members and appoint them, and to give a little bit of a prestige, to be very honest with you. It was called the court. but it is not necessarily court in the same sense or synonymous with the judicial or national courts. So maybe I thought of clarifying a little bit of a background and history to why the term court started about 100 years ago and is now overly prevailing.
Thank you, Sarah. Do we have any further questions? This is the gentleman on the front. Could we get the mic over here, please? Just right at the front, please. And I think after this question, we will break for lunch.
Thanking all the panelists for their good effort. I would just like to emphasize the subject of the funder. Yes, it's a bit new in some countries that they are not or included in their arbitration rules. The thing is that funding is, when we talk about is it applicable to Sharia or not, saying that it's not that hard to make that a contract or a contract between the funder and the arbitrator or the other party. It's not hard to smartly form a contract applying Sharia law. So it's, and this issue is something already been discussed more than 10 to 20 years ago in the Islamic financial issues. So it's a financial going to arbitration. Smartly forming a contract is and to apply Sharia, even although there is a variety of ways to form that, applying Sharia, applying even what the funder wants and is the beneficial, is the money that he wants to take. So this is not that big issue, I think, to form it in a good way. And lots of people, there is even an Ayufi, you know, in Bahrain, it's they have their rules. It's all there. So I don't think there is any problem in that. Yes, there is the main issues as riba and gharar. But if you went into an Islamic Sharia his specifics, and he write it good, it will be very nice, and it will not be a problem.
Thank you for that comment. Very well put.